Hello students. Today's lecture we're going to be talking about the Texas Judiciary, the Texas judicial system. To get started, there are some basic concepts or some basic terms that we need to understand about the Texas Judiciary. The first is that our judicial system is what we call an adversarial system. What's an adversary? An adversary is an opponent. It's a foe. It's an enemy. There are two sides to each case. There are two parties. The first party is the plaintiff. The plaintiff is the one who's making the accusation, the one who has been harmed. The defendant is the one who is being accused. In Texas, we can break our laws into two categories. The first, civil law. And you see I've included a link to the various civil codes in Texas. If we click on it, Agricultural Code, Alcoholic Beverage Code, Auxiliary Water Laws, Business and Commerce Code, Business Organization, Education, Election, Estates, Family, Finance, Government, Health and Safety, Human Resources. So you can see there are a number of different civil laws in Texas. Civil law is going to deal primarily with individual or property rights. Contracts. Did you sign a contract with somebody? They didn't honor their end. You didn't honor your end. That kind of thing. Civil law, the purpose is to assign responsibility, not guilt. We have to decide who is the most responsible for the harm. And when we're talking about harm, I actually need you to expand your thoughts. When we're talking about harm, it is not only physical harm. Have you been harmed? If you're in a wreck, you're okay, but your vehicle has been totaled. Have you been harmed? Yes, you don't have access to your car. You can't use it to do the things that you need to do. So there's other types of harm besides physical harm. Need you to remember that. In civil law, the plaintiff and defendant, these two sides, are often private parties. That means that they can be an individual, they can be a business, they can be a corporation. Can they be the government? Yes, they can. Can the government sue you? Yes, it can. Can you sue the government? Yes, you can. So while in most cases the plaintiff and the defendant are private parties, the government can be a member, they can be a side in a civil lawsuit. Disputes are usually set out in a petition. This is just your side of the story. You are explaining how you have been harmed by the defendant. To win your case, you must reach a certain level of evidence, level of proof, burden of proof, whatever you want to call it. The burden of proof you must reach is a preponderance of evidence. Can we associate a number with preponderance of evidence? In this case, yes, we can. Remember, in civil law, we're looking to assign responsibility. We're not worried about guilt. We are looking to see who is the most responsible for the harm. So, what number can we assign to preponderance of evidence if we are looking for the most? Yeah, we're looking for a majority, or 50% plus 1. If you can prove that the defendant is majority responsible for your harm, you will win your civil lawsuit. If you win, remedy is relief from or compensation for the violation of legal rights. Now, one of these is really easy to understand. That one should be compensation. What is compensation? If you go to work, you are compensated for your time and effort. How are you compensated? You're paid. So compensation is money. You are being awarded money because you have been harmed. Now, what is relief from? Relief from does not involve compensation. You have been harmed in whatever way. Say that there's a club across the street that they keep on playing their music after hours. If there's a city ordinance that says at 10 o'clock the volume's supposed to go down to 40 decibels, and 10 o'clock to 1 o'clock they're still blasting it at 70 decibels. If you sue, have you been harmed? Yeah, you're not getting sleep. If you don't get sleep, can this harm you physically and mentally? Yes. So you have been harmed. You sue, you go to civil court, the jury agrees with you or the judge agrees with you. Yes, they are the majority. This club is the majority responsible for your harm. What can they order them to do that makes you whole, that stops harming you? I'll get it in a minute. But doesn't involve money. They can simply order them to turn down the music at the proper time. That is relief from. They can order them to start following the law, and they have offered relief from the harm. You are no longer being harmed. Now, criminal law, criminal cases, this is going to deal with proper behavior as defined by law. Where do we find the laws? How do we know what actions in Texas are legal or illegal? If we're talking about our criminal cases, we look in the Texas Penal Code. And this is what I originally opened to. I actually recommend everybody to look through the Texas Penal Code just to see what kind of crimes that we have. Here's homicide, this would be murder or killing somebody, kidnapping, unlawful restraint of smuggling of persons and smuggling of persons, trafficking of persons, sexual offensive, assaultive offenses, offenses against the family. Look over the intoxication and alcoholic beverage offenses, because some of these we perform actions that we don't think about that could constitute us driving while intoxicated. So look over Chapter 49, the intoxication and alcoholic beverage offenses. Anyway, we find our criminal conduct, our criminal laws in the Texas Penal Code. In criminal law, once again, you have two parties. You have the plaintiff, you have the defendant, the accuser versus the accused. In criminal law, at the trial level, and I haven't gone over the trial level yet, I will in a few minutes, the case is initiated by a government prosecutor. So, in criminal law, at the trial level, the plaintiff, the accuser, is always the government. Specific charges of wrongdoing are spelled out. We state how, when, why, where, all this good stuff. We believe that John Doe broke the law. We then ask Mr. Doe, how do you plead? Guilty or not guilty? Mr. Doe will plead. If you plead not guilty, you're going to go to trial. Strict rules of procedure are used to evaluate the evidence. We are there to make sure we have this during this trial. We have a judge there to make sure that the defendant gets all of the rights that they are entitled to, all the protections that they are entitled to. That's why we have these strict rules of procedure. Guilt. Guilt is proven beyond a reasonable doubt. Now, with preponderance of evidence, I was able to associate a number with responsibility. Who was the most responsible? That number was 50% plus 1, or the majority. Can we associate a number with guilt beyond a reasonable doubt? The answer is no. We cannot do this. Why? Because it's going to be different for everybody. While one might find a story or a defense perfectly reasonable, perfectly acceptable actions, another person might not. So, no, I cannot provide a number for this. Determination of guilt results in punishment. If it is determined that you were guilty of this crime, you will be punished in various possible ways. Jurisdiction. When we are talking about jurisdiction and the Texas Judiciary, we see that there are I'm looking at the slide number. We see that there are 3 definitions for jurisdiction. The first definition of jurisdiction is the type of law that the court has the authority to hear. Do they have the authority to hear civil law cases? Do they have the authority to hear criminal law cases? Or some courts, they have the authority, they have the jurisdiction to hear both civil and criminal cases. The second type of jurisdiction is their area of authority. City courts are going to have jurisdiction in crimes that occur in city limits. County courts are going to have jurisdiction in crimes that occur in the county limits. So this kind of thing. Their area of authority. The third type of jurisdiction, and the one I want to focus on right now, refers to the court's job. What are they doing? What is the purpose of them holding a trial, of them hearing a case? This is the type of jurisdiction now. Out of this type, in regards to the court's job, there are 2 types of jurisdiction. The first is original jurisdiction. Original jurisdiction is the court's authority to hear a case for the first time. This is where we're going to decide the facts of the case. The judge oversees procedure. The judge is the one who's going to make sure those proper procedures are followed. Usually, a jury will evaluate the evidence and determine guilt or innocence. I said usually you as the defendant, have the right to decide to have a trial by judge or a trial by jury. Most of the time, your attorney will tell you trial by jury. But that's original jurisdiction, the authority to hear a case for the first time. The second type of jurisdiction is called appellate jurisdiction. Appellate jurisdiction is the power of a court to review the decisions of a lower court. the power of a court to review the decisions of a lower court. Once again, I know we haven't gone over higher or lower or anything like this. Give me just a second and we will. An appellate trial, it does not involve a new trial. There are no new witnesses called, no new evidence presented, no new facts. All we're doing in this appellate trial is we're going to sit there and make sure that the proceedings at the trial court were proper. The proceedings were based on law. Once again, we're not looking for new facts. What if the appellate court decides that the lower court was wrong, that they didn't follow proper procedure? Then we will see something called a reversal. The higher court will reverse the lower court decision. This reversal means that the lower court's decision was an error. It was improper. The lower court made a mistake. An individual waives the right against double jeopardy if you appeal the case. Double jeopardy is something we'll talk about in our next section. Now, I've been talking about lower court, higher court levels, that kind of thing, and I said I will explain it to you in a minute. Now, on this next slide, I'm going to show you a picture, and it's going to seem a bit confusing over what I am getting ready to say. I will explain it though. What you need to know in the Texas judicial system, we are a three-tiered system. We have 3 levels in our court system. The lowest level is the trial level. The trial courts, these are going to be the courts of original jurisdiction. These courts have the authority to hear a case for the first time. The mid-level are what we call the appellate courts. So you have appellate here at the top of the slide. The appellate courts, or it could be called the circuit courts. The appellate courts or the circuit courts have the authority to review the decisions of the trial court. They get to decide if the lower court followed proper procedure. The highest court, the court of last resort, we actually have 2. We have the Texas Supreme Court, which deals with civil law, and we have the Court of Criminal Appeals, which deals with criminal law. These 2 are exclusive. Texas Supreme Court only deals with civil. Texas Court of Criminal Appeals only deals with criminal. These are the 2 highest courts in the Texas judiciary system. For the purpose of this lecture, for the purpose of this class, both of these only have appellate jurisdiction. Now, I say that because the Texas Supreme Court does have some original jurisdiction, but I don't get into that. So all I want you to know is that for this class only, this highest level has appellate jurisdiction. Now, to the confusing part. Here's a picture of the court system that I just explained to you. You know, the one I just explained has 3 levels. Now, I'm sure you're looking at this pictures and counting and saying, that's more than 3. You're absolutely correct, that is more than 3. This is 5. But there's a reason. If we look at the district court, the county level courts, the justice court, the municipal courts. If we look at these 4 courts, all of these courts make up the trial level. So all 4 courts make up the bottom level of the Texas judicial system. Here's the Court of Appeals, the intermediate, the Circuit Court, this is at mid-level, Supreme Court, Court of Criminal Appeals. This is our courts of last resort. These are the highest courts. So yes, I understand it looks like 5, but we still only have 3 levels. Let's talk about these courts. Municipal courts. They are created by the Texas State Legislature under constitutional authority. Students, that's going to be an overriding factor. Every court we talk about, the Constitution grants the state legislature the authority to create new courts when they are needed. Jurisdiction. Municipal courts have original jurisdiction in enforcement of city ordinances and Class C misdemeanors originating within city limits, and in civil cases involving dangerous dogs. So, city ordinances, noise ordinances, might be site ordinances. You know, you have to keep your yard mowed, you have to keep your house in good shape, in good repair. You can't have broken down vehicles parked in front of your home, that kind of thing. Those would be city ordinances. So, original jurisdiction over violations of city ordinances. These municipal courts also handle minor violations of state law. When we say minor violations, we mean the lowest level of violation of state law. We are talking about Class C misdemeanors. In a Class C misdemeanor, the punishment is a fine, $500 or less. So maximum punishment is $500. It does not include jail time, incarceration. A Class C misdemeanor, no incarceration is possible. Most cases are going to be traffic or parking violations. Number. How many municipal courts do we have in the state of Texas? As of 2018, there were 940 municipal courts. Their caseload. Caseload means how many cases does a court handle. Out of these 940 municipal courts in fiscal year 2018, they handled almost 594,000 cases. Almost 594,000 cases were filed in Texas municipal courts. Now, these courts, these judges, they do have other duties. Municipal court judges, they're real judges. They can sign and issue search warrants. They can sign and issue arrest warrants. The next court I want to talk about, the Justice of the Peace Court. Let me go back here for just a second. We just talked about the municipal court. Here's the justice court. So we're talking about that other leg on that bottom level. So we're still in the trial level of the 3-tiered judicial system. JP, Justice of the Peace, we can just call it JP, created by the Texas Constitution. Jurisdiction, they have original jurisdiction over Class C misdemeanors, so they have jurisdiction over criminal cases, but the JP court is different. and that it can act as small claims. This means you can sue people in JP court if certain prerequisites are met. So the Justice of the Peace Court, the JP court, also has jurisdiction over civil cases. The number of courts, 803 as of 2018. Justice of the Peace continued. Jurisdiction over criminal cases if the fine is under $500. So, once again, Class C misdemeanors. Civil matters if the amount in question is less than $10,000. Now, this is something that we have changed in political terms relatively recently. I have an article in here about changing the law to higher JP limits because it used to be $5,000. Now, Justice of the Peace, they are a real judge. This means they can sign and issue search warrants. They can sign and issue arrest warrants. They are real judges. Qualifications. How do you get your job to be a JP? Well, got to be a registered voter. And guys, that's it. Have to be a registered voter. Don't have to go to law school, don't have to be a practicing attorney, anything like that. If you're not a practicing attorney, don't worry, you have no experience with law, civil or criminal, and the state of Texas has your back. We will send you to a 40-hour training course where you can learn about various types of law, because that 40-hour training course makes up for the 3 years of law school, right? Yeah. JP is elected to a 4-year term. Their duties. JPs get to perform marriages. Coroner duties. If there's a county that does not have a coroner, the JP will fill in. What's a coroner do? They pronounce, yes, they are officially dead. They died of natural causes. What happens if the JP doesn't have any medical experience? Well, doesn't matter. You still get to say if cause of death was natural or not. A JP is an ex officio notary. Ex officio is a term you will hear again. Ex officio simply means, because of this, I am that. Now, to become a notary in the state of Texas, you fill out the application, you send the application to the state along with your fee. They get your application, they get your money, they want your money, and then they will send you your little permit to become or to be a notary, to be able to legally notarize forms. That is what you and I have to do. We have to go through the little bit of paperwork, the little bit of bureaucracy. The ex officio notary, the JP, they don't have to go through that bureaucracy. Because of this, I am that. Because they are a JP, they are automatically a notary. Then they get to preside over small claims court. Their caseload. Are they busy? Fiscal year 2018, more than 529,000 new cases were filed in Texas JP courts. So, yeah, they're busy. Other duties. Once again, issue search or arrest warrants, serve as a coroner in counties with no provisions for a medical examiner. I think this one is neat. The JP gets to sign eviction notices. This is the only court in Texas that can legally sign an eviction notice. If you own a home you're renting out, or if you're renting out apartments, if somebody gets behind on their rent, you can't go kick them out. You have to go get court approval. You have to go to the JP court. Annual reports on the Texas court, you can just look over these and see the various types of courts, what they do, that kind of thing. Nothing that I'm going to be worried about. The next court we're going to talk about, county courts at law. County courts at law. Please put an asterisk by this title, because a little bit later I'm going to talk about another court that has a very, very similar name. I want you to understand, I want you to be able to differentiate between the county court at law and this other court. Created by the Texas legislature under constitutional authority. These courts, they're going to have original jurisdiction over Class A and Class B misdemeanors. Class A and Class B misdemeanors. So, misdemeanors are less serious crimes, but this sounds odd. They're the more serious of the less serious. Driving while intoxicated. Assault, depending on who you beat up. Theft, depending on how much you steal, the value of the item that you steal. Possession of drugs, depending on what it is, that kind of thing. Now, they do have appellate jurisdiction over local courts, and all this means is if you lose, you have a court case in the JP court, if you have a court case in the municipal court, you can appeal your case to the county court at law. And the county court at law, and this is what I want you to know, this is what you need to remember. The county court at law, if you're hearing this appeals case, there is no record. Nobody at the lower levels of the court creates a court record. So the municipal court, the JP court, don't create a court record. The county court has nothing to look at to see if proper procedure was followed. So if you appeal, you're going to get what's called a trial de, D-E, novo, N-O-V-O, a trial de novo. All this is you're going to get a brand new trial in the county court at law. So no trial de novo. 245 county courts at law as of fiscal year 2018. Caseload, 94,341 cases were filed in fiscal year 2018. The judge is elected to a 4-year term. Like any other judge, they can sign and issue arrest warrants, they can sign and issue search warrants. This is the third court out of those 4 that make up the trial courts. So if you're thinking about that 3-tier judicial system, we are still at the trial level. This next court is the last one. County district courts. This 4th court finishes up the trial level. Once again, created by the Texas legislature under constitutional authority. Now this is a lot of writing, just let me do this easily. They have original jurisdiction, the authority to hear a case for the first time over felony criminal cases, or most serious criminal cases. Family law. This could be, divorce, custody case hearings of children, that kind of thing. Cases involving title to land, election law. You can sue in county court if the amount is $200 or more. In densely populated counties, the district courts may specialize in civil, criminal, juvenile, or family law matters. So when you get to your bigger counties like Harris County, you're going to have district courts that only have jurisdiction over criminal cases. You're going to have courts that only hear family law, juvenile law, that kind of thing. Now, in the less densely populated counties, these district courts will have authority over both civil and criminal law. This means that the judges there have to know both sides. They have to know both civil and criminal law. .469 district courts as of 2018. It's considered to be the chief trial court of the state. The district court is considered to be the chief trial court of the state. We are actually going to have more trials at this level than the other three. I'll explain why in our next video lecture, our next section. The state district court actually handles more cases than the U.S. district courts. Once again, that's an explanation that's coming in the next video lecture. 2018, Texas district courts took on they took on about 195,000 new cases. So these four courts, this wraps up the trial level. All of these are courts with original jurisdiction, the authority to hear a case for the first time. Now we're moving into that mid-level. Oh, I forgot this, I'm sorry. Most juvenile cases are tried in district court. I'll explain that once again the next lecture. Middle level, courts of appeals. I took this slide from a book and I love it because it does a really good job of telling you the physical locations of the court. It does a really bad job because there's a typo on here. Can you look on this map and tell me what the typo is? Yes, the typo is there's two number ones. There's a one in Houston, there's a one in Amarillo. The one in Amarillo should be Court 7. Houston is served by two courts, by the 1st, the 14th. Why? Based on population. That's why. We have more court cases. Now, Dallas and Fort Worth are actually close, but Dallas itself has one and Fort Worth itself has one. Houston has two. So, Court of Appeals, these circuit courts, these intermediate courts, as you just saw, there's 14 Court of Appeals that serve Texas. Each is assigned a district, the 1st, the 14th district, the 7th district. And this is where that jurisdiction, that physical area of authority came in. These courts of appeals have physical jurisdiction over certain physical locations. So like if a case happens in Dallas, they have to appeal the case to the court that oversees Dallas. They couldn't appeal it down to a court in Houston or anywhere else. They hear appeals for both civil and criminal cases. Now let's talk about some differences. These appellate courts have appellate jurisdiction. They're going to make sure that the court at the lower level, the trial court, followed proper procedure. How do they differ? The first is, how many judges do you see in a trial courtroom? If you've ever seen a courtroom on TV, if you've ever been in court for whatever reason, there's one judge. They're making the decision, and they're actually not interacting much with the attorneys other than saying, yes, I'm going to allow this. No, I'm not going to allow this. At the appellate level, it's totally different. The appellate trial, your argument is heard in front of a 3-judge panel. So there are 3 judges that you are arguing to, you are making your case to. They get to interact with you. They will ask the attorneys questions. They will ask for clarification. These appellate court trials, they operate under a very strict timeline, usually about an hour and a half. The plaintiff's attorney gets to make their argument. They have X number of minutes. The defense gets to make their argument. They have X number of minutes. The plaintiff gets like a short, maybe 10, 15 minutes to rebut what the defense said. The defense gets 10 or 15 minutes to rebut what the plaintiff just said. And that's it. There's none of this days and days, weeks and weeks on end. It is a short time. But once the trial's over, you don't get a verdict right then and right there. Once the trial is over, these 3 judges will go and they will do what is called conferencing. They will meet at a later date in conference. They will talk about the legal merits of the case. They will decide who won, who lost, based on this legal reasoning, and they will write their opinion telling us who won and who lost and why they decided that way. These Court of Appeals judges, they are elected to 6-year terms. The candidates must be at least 35 years of age, minimum of 10 years experience as a lawyer or a judge. Highest courts. Remember, we have a bifurcated court system. So now we're at this 3rd level. We're at this top level. We have a bifurcated system because we passed a constitutional amendment in 1891. We wanted to be like Oklahoma. Don't know why, but we did. So we divided our court system. Criminal matters, criminal law, to the Court of Criminal Appeals. Civil law goes to the the Texas Supreme Court. So let's start off with the Court of Criminal Appeals. This is the highest state appellate court in criminal matters. Means if you lose here, if you cannot go to the federal level, it's over. Remember, the Texas Supreme Court only hears civil. You can't lose at the Court of Criminal Appeals and go over there. They don't have jurisdiction. The judges elected for 6-year overlapping staggered terms. They must be at least 35 years old, must be a lawyer or judge from a lower court with 10 years experience. Okay, now your appeal, it's going to happen just like the appellate level. Certain time frame, they get to interact with you. The only difference is at these 2 highest courts, the Court of Criminal Appeals, the Texas Civil Court, or Supreme Court, they have 9 judges. The Court of Criminal Appeals has 9. The Texas Supreme Court has 9. So same thing as the civil or as the appellate court, but instead of arguing in front of 3, you are arguing in front of 9. The Court of Criminal Appeals has exclusive jurisdiction over automatic appeals and death penalty cases. Let me explain what this means. At the lowest level, the trial level, do the courts have a say? Do they get to pick which cases they're going to hear? No, they don't. These courts of original jurisdiction, they have to hear every case that's in front of them. Now, at the appellate level and the court of last resort, so the middle level and the highest level, they get to cherry pick. The appellate court, the circuit court, gets to cherry pick which cases they hear from the trial courts. They don't have to hear them all, and they won't even come close. The 2 highest courts, the Texas Supreme Court, the Court of Criminal Appeals, they get to cherry pick which cases they're going to hear from the Texas Circuit, or from the Texas Court of Appeals, the circuit courts. The one exception, the Court of Criminal Appeals does not get to cherry pick. If you are tried in district court for a capital offense and you are convicted, you are given the death penalty. You have one automatic appeal to the Court of Criminal Appeals. You're going to bypass that mid-level, you're going to bypass the circuit court, the Court of Appeals, and you go straight up to the Court of Criminal Appeals. They have to hear your appeal. Now, what if you lose that appeal? At a later date, can you appeal for some other reason? Yes, you can. But then it has to go through the proper procedure. You appeal, the appellate court has to decide to hear it. They hear it, they have to rule. If they rule against you, you get to appeal again. Then the Court of Criminal Appeals, they get to decide if they're going to hear it or not. So once you lose that first automatic appeal, you're not guaranteed another one. I mentioned death penalty cases, these capital punishment. Capital punishment was restored in the United States in 1976. We had placed a moratorium. The Supreme Court had placed a moratorium from 72 to 76. We could not execute people. In 76, the Supreme Court decided that the state laws regarding death penalty had been rewritten to the point where they were not discriminatory. So they said you can start using the death penalty again. Did Texas use it? Does Texas use it? Yes, we do. Where do we rank in death penalty? We rank number 1. Texas has executed far more individuals than any other state. Texas Supreme Court. Final Court of Appeals in civil and juvenile cases. What I'm going to go into greater detail about in your next lecture, juvenile cases, even if they are criminal cases, most of them are tried in civil court. Most juvenile criminal cases are tried in civil court. That is why the Texas Supreme Court has jurisdiction over juvenile cases. I told you there was a little bit of original jurisdiction, writ, issuance of writs, conducting of proceedings for involuntary retirement of judges, removal of judges. But what I really want you to know, and like I said, Texas Supreme Court, most of their duty, most of their job comes from the appellate jurisdiction. To be a Supreme Court judge, you must be 35 years of age, a citizen of the United States, a resident of Texas, and you must have been a candidate. The candidate must be a lawyer or judge of a court of record for at least 10 years. Once again, what I find odd about these, and the Supreme Court, same thing, the same number. There's 9 justices on the Supreme Court. The court hearing operates the same under that time limit. 9 justices on the Court of Criminal Appeals, 9 justices on the Texas Supreme Court, total of 18. But the trials operate the same way. Well, what I was going to say is what I find interesting about the Supreme Court and the Texas Court of Criminal Appeals. So, judge must be at least 35 years of age. How old do you have to be governor? Do you remember? You only have to be 30. To run for the state senate, you've got to be 26. To run for the state house, you have to be 21. So for our position for judge, this is the oldest age requirement that we have. Some other things that I want to go over. Grand jury. A grand jury is a 12-person jury. This is going to occur. We're going to have grand juries for district courts for felony criminal cases. They determine if there is sufficient evidence to try an individual. The prosecuting attorney, the government official, will come to the grand jury, the 12 individuals, and say, I believe John Doe, once again, committed a crime. This is my proof. This is the evidence I am presenting to you to indicate, to show why I believe this individual committed a crime. If 9 of the 12 people agree, if 9 of the 12 people in the grand jury agree, yeah, there's sufficient evidence, we need to have a trial, we need to have further investigation, then the grand jury will issue an indictment. The indictment, the accusation issued by a grand jury, this is the formal accusation. A true bill is just an indictment already approved by a grand jury. Perhaps the person is not there the defendant's not there to testify, they're not in custody for whatever reason. They're going to issue a true bill, they're going to issue an indictment anyway, then a warrant for their arrest will be issued. How do you serve on a grand jury? Most part, this is a volunteer position. Contact your district courts. Ask for probably the court clerk, and he or she will be able to tell you how that particular district court selects grand juries. And it's a paying job. It's a part-time paying job. For college students, if you're the traditional student, this might not be a bad deal for you to look into. Petit Jury. Your Petit Jury is your trial jury. This is a jury in a civil or criminal trial. County courts, these misdemeanor courts, have 6-person juries. District courts have 12-person juries. The felony courts have 12-person juries. Jury panels are selected from driver's license list. So when you get that jury summons, it's just because your name was randomly selected. We being the state, actually changed this. We used to send out our jury summons based on registered voters. But then research showed that people would not register to vote so that they would not receive a jury summons. So we changed it. Now it's coming from driver's license list. County Commissioner's Court. This is my concern. County Commissioner's Court, sometimes called County Court. This is the one I did not want you to get confused with County Court at Law. These are 2 different things. These are two different ideas, jobs, whatever you want to call it. The County Court, or the County Commissioner's Court, created by the Texas Constitution. Each county has a county court. We have 254 county courts. So how many counties do we have in Texas? Should be able to tell me if each county has a county court. And I'm telling you we have 254 county courts. We have 254 counties in Texas. These courts have limited jurisdiction. What I mean by that is that most do not perform any criminal or civil court activities. They only serve administrative purposes. They serve as the head of county government. Now, county court is run by something called Commissioner's Court. Commissioner's Court consists of 5 people. And county size doesn't matter. It's always going to consist of 5 people. It's going to be the county judge and 4 county commissioners. These 5 people make up Commissioner's Court. They are the head, the administrative head of county government. So they set tax rates, they create county ordinances, they oversee the county agencies, they do a budget to pay the county agencies. Simply, they do administrative. County court at law actually does hearings, actually hears criminal cases. I provided a link to Harris County Commissioner's Court. They are, Harris County is the largest county in Texas. So if you wanted to look around at some of their duties, who they are, you could go do that. Now, one other court, the last court I want to talk about, is something called a statutory probate court. Statutory probate court, created by the Texas legislature. Remember I told you this was going to be the overriding or the overwhelming? Yeah. 18 courts as of fiscal year 2018. There's only 18 throughout the entire state. They have original probate jurisdiction. Now, let's talk for a second. I'm getting ready to come up with a lot of words up here. Let me explain. In the state's 6 largest metropolitan areas, so the state's 6 largest cities, we have our own statutory probate courts. They have original and exclusive jurisdiction over their county's probate matters. So Harris County or Houston, then Dallas and Austin, probably Houston, Dallas, San Antonio, probably Austin, probably El Paso. If we're talking about probate courts and what they have jurisdiction over, probate matters, this is going to be wills. When somebody passes, you take their will to probate court. They want to make sure that the will is followed, that the deceased's wishes are followed as they intended. Guardianship cases. This isn't custody cases. This isn't family law where mom and dad divorce. This could be guardianship where you become guardian for your parents. If something happens to your parents, they pass. If you have a sibling underage, perhaps you become their guardian. It could be something like this. Mental health commitments. If people believe you're a danger to you or others, they can go to the statutory probate court and they can order you to go in for an involuntary mental health evaluation. Now, if you're deemed that you're sane, if you're deemed that you're mentally healthy, you're not a danger, you are let go. But if they decide, if this mental health professional decides that you are a danger, well, then you're going to have to stay in. Notes. I said there's 18 statewide. So, in the areas that don't have these statutory probate courts, the Texas legislature has the authority to place this probate court designation in other courts. So, what that means depending on how the Texas legislature assigns the jurisdiction to courts, we could see these statutory probate courts these matters could be heard by a county court at law, district court. So if your county does not have a statutory probate court, that power will be assigned to a certain court in that county. Caseload, fiscal year 2018, there are about 106,000 new probate and guardianship cases filed. So, pretty good number. Last thing I want to talk about, and we have been talking about it, is the selection of judges. Now, in Texas, I've been telling you, we elect our judges. We elect them in partisan elections. This means that we know what political party the judge is running as a member of. Are they running as a Republican or are they running as a Democrat? They're elected to a 4-year term or a 6-year term. Oftentimes, for whatever reason, the judges do not finish their terms. If they don't finish their term, you know this, we've gone over this, the governor gets to appoint a replacement. The governor gets to appoint a replacement with the advice and consent of the Texas Senate. Well, other states use something called the merit plan. In the merit plan, the only way onto the bench is you are appointed by the governor. In Texas, you're running for an election. You can choose to run again. You can choose to run for mayor, or not mayor, excuse me, a judge. You can run against the incumbent, the person that's already there, whatever. But you have the option to run and get on the bench. Under the merit plan, the only way onto the bench is you are appointed by the governor. You serve your first term. Well, then after your first term, you are running for re-election, but you are not running against an individual. You are just running to stay. You're running for re-election. You're running to stay in that position. You are retained by election. What if the popular vote, what if less than 50% says you deserve your job? You're out of a job. And now, the merit plan, the governor is going to appoint somebody else. So you don't run against another individual. You are basically running against yourself.